Okay, go ahead and call this meeting back to order. Ready to proceed? I believe you had the floor. Okay.
I will give it to you, Mr. Cook. Evidently, I didn't understand exactly what I'd been told.
I'm getting there. Where's that letter on March 18th?
Whether you understood me or not, you told this board that you tried to send the city a compromise and the city wouldn't even respond. And that was not a true statement, was it?
Doesn't appear to be.
Doesn't appear to be, it wasn't. Yes or no?
Yes.
In fact, let me refresh your recollection, because I want this board to know exactly what happened. Your lawyers sent a letter dated March 17, 2014. It's in the exhibit book. It's number 2. And it went through all of the summary of the discussions that the lawyers had, Mr. Geary and I, with your lawyers over the phone on March 5th. You want to take a look at the letter?
No.
And it says, in our telephone conference call, this is March 17, 2014, your lawyer says, Mr. Moore, you and Matt clearly stated the Board of Aldermen does not want to terminate operations at Valley Speedway, nor does it desire to terminate the conditional use permit that was issued for the Speedway, as well as the drag strip, MX track, and football stadium. These uses are all part of a single conditional use permit. You indicated that the board recognizes that Dennis Trout Valley Speedway has done a number of items in past years in an attempt to address the noise complaints, etc. You remember that letter?
No.
You don't?
I did not get the letter.
Your lawyer didn't send it to you?
Did, I don't remember.
Well, did he send you, now, I'm not going to read the whole letter because it's an exhibit, the board can read it. But it was copied to Alexa Barton, here, Mayor, Board of Aldermen, there, Dennis Shrout at valleyspeedway.com, that's you, isn't it?
That's me.
And Patricia Jensen, that's Mr. Moore's associate. So your lawyer did send the letter to you, didn't he?
Evidently.
Okay. And in that letter, you stated, it goes on to say, me, stated that the board is appreciative of those measures. Now, here's the response that you said we didn't make. And your letter was sent by your lawyer to me March 17, St. Patrick's Day. March 18, I responded. As oftentimes occurs, the devil is in the detail, and the words used can cause upset and confusion. This is precisely what has happened with your, quote, summary, quote, close quote, of our meeting March 5th, 2014. I want to continue in the spirit of cooperation, but I also want the record clear. Your characterization of what was stated is not completely accurate. We made it perfectly clear the board did not want to terminate the CUP as it applies to Mr. Trout's operation. We also made it clear we were not discussing the Sandregs or any other operators, only Mr. Strauss. Further, we stated the board was running short of patience with Mr. Strauss and his attitude about his operation. It is difficult for us to continue to discuss options when you offer your conclusions of what you think was said and meant during our meeting. We explained to you that the noise and Mr. Strauss' continuing violation of both the decibel limit and the other codes violations make it difficult to reach a compromise. While Mr. Strauss may have the right to conduct a racing operation, he does not have the right to violate the terms of his CUP, which sets the maximum decibel limit. Being able to conduct races does not include violating the sound restrictions. Did your lawyer send you my comments to his letter?
Honestly, I don't know.
Now, you said you had between 500 and 1,500 people coming to that racetrack every race?
Depending on the event, correct?
So 500 minimum, 1,500 max. Do you charge admission?
Yes.
How much do you charge?
Anywhere from $10 to $15 for adults, and kids are anywhere from $5 to free. We do specials all the time of giving discounts.
You sell tickets? Sell concessions? Yes?
Yes.
Okay. How many employees do you say you have?
Counting the concession staff, there's probably 15 to 20.
Do you remember your application for a license renewal for your Impact Motorsports?
Yes.
I'm going to hand you what's in March, the city's, well,
No, you just marked 12.
13.
Yeah.
13.
13. That's a good point. I'm going to offer, Your Honor, City's 12, which is a copy of Mr. Moore's letter to me dated March 17th, and my response, March 18th.
No objection.
Okay, Steve it.
Now, Mr. Stroud, thank you. Mr. Stroud, here's City Exhibit 13. This is your occupational license renewal. Well, first, that's what I say, is you can identify it. Is that your occupational license renewal?
That's what it appears to be, yes.
And what's the date that you filed it?
6/9/14.
And number of employees other than owner. What did you tell the city was the number of employees that you had?
The people that do the concessions is the church, and I do a donation to the church. I don't pay any of them. It's a donation.
Sir, listen to my question. What did you tell the city, the number of employees?
1.
Okay. And what did you tell the city 2 minutes ago the number of employees was?
On race day, it's about 15 to 20.
Offer City's Exhibit 13. Did I give you a copy?
Yes, you did. No
Most of
objection.
those people are,
Okay, accepted.
work for the church, and I don't pay them. I pay the church. And most of the other ones are volunteers. They don't get a salary, so I guess it's how you want to look at it.
I'm not looking at it any other way, just looking at whether you're telling the truth then, 2 minutes ago, or now. That's what I'm trying to determine. Nothing further.
Okay. The board have any questions for Mr. Strout?
Couple. Are you inspected annually by the fire department?
I think they've been out once,
5 years?
I think, yeah.
Have they ever,
Last fall, I think.
have they ever given you any reason to believe they wanted your schedule?
Do what? I'm sorry.
Did they give you any reason to believe they wanted your schedule?
No.
Have you been inspected by the city?
Not that I know of. I mean, as far as the city coming out, and I get inspections from like the health department and stuff like that, but
I wonder if anyone come out and say anything to you about a need for more signage or...
no.
Okay. Okay.
Anyone else have any questions? Okay, I have a couple. Mr. Shrout, has the entrance you have currently, has that always been the entrance that you've had, or have you changed the entrance?
Been there since the inception of the racetrack.
Okay. I couldn't remember if that was the original entrance or not. Next question is, you'd mentioned that you had changed mufflers from the mufflers that the first owners had on because you'd found some that were doing a 10 decibel reduction, is that correct?
8 to 10,
8
correct.
to 10. Are there mufflers out there that you know of that do more than 8 to 10 reduction?
Not that I know of. I call these muffler places all the time, and what is out there right now is the best we've come up with in today's market.
Okay. Awesome. Would it be fair to say that you've not been given a written notice from the city prior to this revocation hearing because yourself and the city, we were working together to try to find a solution to this issue that didn't involve citing you or fining you or revoking your permit up to this point? Would that be fair to say?
I would guess that yes, we were trying to work a compromise that would work for everybody, so that would be an assumption that I would agree with.
That's all I have. You can call your next witness.
This time I'd like to call Jerry Lichtai. Mr. Lichtai, where do you work?
Management Strategies Group Incorporated.
And what position do you hold there?
I am now the sole owner of the company. My business partner retired 2.5 years ago.
How long have you owned the business?
1995.
Businesses, what do you do?
We are a consulting firm in environmental safety, DOT, mine safety. We work with a wide variety of organizations here locally and nationally.
Part of that, do you perform sound studies?
Probably in my 42 years of doing what I do, I've probably performed several thousand noise studies.
Were you engaged by Mr. Shrout to conduct a sound study at the Valley Speedway, dates of May 16 to 17?
Yes, I was.
And as part of that process to do the sound study, did you become familiar with the requirement of the city conditional use permit?
What I was able to find out, the conditional use permit had a statement of 65 decibels. Did not say anything else besides that.
Didn't say anything about methodology to be followed to determine and how to arrive at a conclusion of whether or not it is above or below or at 65 decibels.
No, it did not.
Okay, you've done several thousands of these. In this instance, given the fact that you were charged with the responsibility for conducting the sound study for the Valley Speedway to determine where it's noise registered with respect to the conditional use permit, what criteria did you use, or did you determine to use, to provide and perform the measurement for the sound?
Whenever you're doing an environmental study, they're a little bit different than a, say, industrial study, like in a manufacturing setting. I typically would defer or reuse the EPA guidelines, the Federal Highway Commission, and in this instance, I also used HUD.
And when you say HUD, I mean, you're talking about the Housing and Urban Development?
Yes.
Okay, and specifically, what standard of measurement are you referring to?
You're doing a time-weighted average using the noise dosimeters. The peak level that you see up there a while ago on that one chart, that's more or less a instantaneous reading that would last for approximately 1 second. Things that last, based on the study that I did, things that would last approximately a minute in length that exceeded 60 decibels would be recorded.
Is this the chart you're referring to?
Yes, that is the summary chart found in the Appendix 1.
And we're specifically now referring to the environmental noise survey that is our exhibit number 35.
Yes.
In your professional opinion, then, is it your opinion that the methodology that you selected to measure the noise at the racetrack was a reasonable methodology?
Yes, based on the time length that I was given that the track would normally be open, which was approximately 4 o'clock in the afternoon on a Saturday to approximately 11 o'clock at night. The study was done during those timelines. Then, if you would, I did not reflect it right there on that one, but if you would reflect on the individual summary sheets, projected out over 8 hours, the one up there, actually, the one that's pointing up at 65.2, that was based on a study that actually lasted 6 hours and 39 minutes and some odd seconds. If you projected that out over 8 hours, according to what the instrumentation that was calibrated before and after, it would fall down to about 60.1 dB for that 8-hour period, which was following the HUD guideline.
Okay, and the HUD guidelines specify
not anything, no 8-hour period in a 8-hour continuous period in a 24-hour timeline exceeding 65.
So, based on the criteria that you used for measuring sound, the chart that we have up on the wall, which is a page from your study, would you tell us what the results are on the column at the far right on May 17?
That, what you're looking at there on that chart, that is the average for the length of time the dosimeters were running. And so that was the average for that period. And so all the, whatever activity was going on, all summarized from the time I started the instrument until the time I shut the instrument off, that was the average for that period.
And to use as a comparison, you did a measurement on May 16, is that correct?
That is correct.
And is that reflected in this middle column?
Yes.
And the results of the study on May 16, did you follow the same methodology as on May 17?
Yes. On Friday, which was the 16th, I had two gentlemen from the city of Green Valley accompany me. I put them in the location based on what they had remembered, the cook, whatever, cook class. Yeah. Based on where they said they had placed them, we placed them in the approximate same location. But unlike that previous study that lasted anywhere from 3 to 10 minutes on those, to get an actual example, we ran it for the a longer period, which would be the approximate time that the operation of the racetrack would be going on.
Okay, and when you refer to the Cook-Flat-Strobel study, again, you're referring to this summary chart of their results.
Yes.
Let's go back to your analysis. Site number 3 is the top one. That's at the north property line.
Yes.
And the result is listed here at 65.2 decibels.
Yes.
Okay. Explain why this is identified at 65.2, but your conclusion is that they're in compliance.
To keep things fair, for those who routinely look at the analysis, they look at the timeline that you do it, it's the average of the testing period. You would then project that out to the full 8 hours, and projecting it out over to the full 8 hours, that's where it would drop down to the 60.1.
So moving on to Site 2, your analysis shows that that's 60 decibels, is that correct?
Yes.
Site 1 is at 60 decibels, and Site 1 is on the west property line?
Yes.
And finally, Site 4 on the east property line is at 64.1 decibels.
Yes.
So again, these are all under the 65 decibel level as stated in the conditional use permit, is that correct?
Yes.
In your professional opinion, based upon this study that you performed, what conclusion did you arrive at?
Well, based on the fact that it was at 65, that they were at or below 65, they would be in compliance, the Speedway.
And again, you chose a methodology to follow that is used by HUD for an 8-hour period in a 24-hour time frame, not
Yes.
to exceed 8 hours.
Yes.
And given the fact that the city's conditional use permit merely specifies a level without specifying a criteria, it is your professional opinion that utilizing that standard is a reasonable standard in this instance?
Yes.
Anything else? Mr. Mayor? Well, that's the summary, yeah. No further questions.
Okay. Mr. Cook?
Well, you brought a lot of facts and figures, and you brought common sense with you, David.
I bought facts and figures. After 42 years of my profession, sir, I do not really like the term common sense, because what is common to one may not be common to another.
That's obvious. That's obvious. That's a very good observation. Exactly the point I'm trying to make.
Thank you.
You want this board to believe that your methodology, would you go back to the prior?
Sure.
Your methodology of averaging the sound over 8 hours, don't you say?
Yes.
You started measuring at 4 o'clock in the afternoon and you stopped at 11, correct?
Yes.
And the races didn't run from 4 o'clock until 11, did they?
That is correct.
And your measurement uses what you call an average over 8 hours, correct?
Yes.
So, all these board members brought their common sense too, the mayor.
And so if you have a longer period of hours to go into the average, it's gonna bring the sound level down, isn't it?
That would be correct.
Of course it's correct.
And when you did the comparison with Cook, Flight, and Strobel, which Mr. Shrout said mirrored, his words, mirrored his sound study, they broke it down to the measurement of the actual races, the actual time the race was going on. They didn't back it out to 4 o'clock, wait around, oh, race starts at 7:20. They took precise measurements of the time of the race, correct?
They took snippets of the race based on what I was able to see on the results.
Well, you look at it, you compared it, you put it on your exhibit, so they showed when the race
Sir,
started.
I did not put that on there.
Well, the lawyer did, somebody did. They're trying to show that the comparison. So Cook, Flight, and Strobel precisely measured it during the races, correct?
That is correct.
But you didn't do that.
No.
In fact, as I understand it, because I talked to Mr. Murphy, he was out there,
You took precise measurements, literally, for every minute you were out there, correct? Your sound meter goes like this, measures every stroke for every minute.
yes.
And if you wanted to, Mr. Shrout had told you to, you would have come in and said, here's what I did. I did exactly what they did for this period of time during the race when the sound's way up there. Not at 4 o'clock, not at 5 o'clock, not at 6 o'clock, not even at 7 o'clock. You could have done that, couldn't you?
That is actually reflected in the report. If you go down by minute on each individual one, it does reflect the individual 1-minute timelines.
Then you took that and extrapolated, put in your income or your monthly time average, whatever you call it, and got to a lower decimal, correct?
Time-weighted average, which in any survey done that I've ever done, you pick a spot, a point in time for a period of time and do the study.
I understand what you did, and I think I understand why you did it, but we can agree that if you had tried to replicate the methodology that Cook, Flight, and Strobel did, which Mr. Shrout said mirrored his study, you would have come up with very close to the same results that Cook, Flight, and Strobel did, correct?
I don't know what mirrored Mr. Strobel, the owner of Green Valley Speedway. I don't know which study that he said. My study was not used to compare the Cook Flat.
I didn't say that. I said his study mirrored Cook, Flight, and Strobel.
I didn't see that.
Study.
You didn't see the study?
The only study I saw was the one I did. And
So you didn't refer to what Cook, Flight, and Strobel did?
I looked at their test, I looked at what they did. I did not use that as a comparison, primarily because in reading the report, I could not determine what methodology they were using other than testing a short snippet. My basis for doing a time-weighted average is what it is over a given period of time. Right now, I know I talk above 65 decibels, so if I had my decimeter on, I would be above 65 and would last for the length of time my voice carries.
Well, let me submit to you, sir, that one of the reasons for a noise study is to try to measure what the noise level is during the races as it impacts the people who are bothered by the noise. Correct?
That is your method.
No, it's not my method. That's just the purpose of a noise study. That's what you did, isn't it?
Purpose of my study was to determine what a time-weighted average would be.
No, the purpose of your study was to measure the sound. To get to your results, you used the time-weighted average. You didn't go into it with the time-weighted average. You first had to measure the sound, didn't you?
Sir, the instruments automatically calculate that in.
I agree. Precisely my point. So if the city had said to you, we'd like for you to do the same methodology and the same bar graph that Cook, Platt, and Strobel did, you could have done that.
Yes.
Okay. And did Mr. Trout tell you that the city actually asked him if we could participate and cost share so that we could have some participation in the methodology and the manner in which the study was done? Did he tell you that?
No, but I gathered by two city employees being there with me on Friday and one of them on Saturday, I thought there was some participation going on. I did not know that.
They're there watching.
I kind of figured that out after about 10 minutes.
But they weren't there to tell you, hey, wait a minute, why don't you do it this way, or why don't you measure it that way?
I don't think they were going to question the method I was using.
Well, whether or not they did or not, that's not the point. The point is, you know, Mr. Strout, we had offered to cost share this with him so we could have some input into the methodology and the way it was measured, and he wouldn't allow it.
I did not know that.
Let's talk about the study itself. When were you first commissioned to do it?
I probably was contacted by him on the first part of May.
Of 2014?
Yes.
And when did you actually, the first work you did on the study was May 16 when you went out and took the measurements when there weren't any races?
Actually, I was out there a few days earlier than that to walk around the area and also to look at the previous report from the Cook, Flat, and Strobel.
Okay.
I glanced through that, basically trying to determine where they had placed the instruments.
Okay. But we can agree that the only measurements you took were May 16, May 17.
That is correct.
Okay. And so May 17 was a Saturday?
Saturday.
And when you completed taking the tests and you prepared your report, when did you provide the report to Mr. Trout?
Because of my travels, I took the report out. I was thinking I took it out on the 9th of June. It could have been the 10th of June. But I attempted at one time to email it, but the location I was at in my travels that week, internet was pretty bad and cell phone reception was even worse. I work in some fairly isolated areas sometimes.
Did you give Mr. Trout the report before or after you went on vacation? Or went out of town? Where you went?
I gave him the report when I got back into town.
Did you give him a draft report for him to comment?
No.
Did you bring your file with you tonight with your notes and your correspondence?
I was not asked to bring those.
I didn't think you were. Did Mr. Trout tell you that he wanted you to do this study to come up with a decibel level less than 65?
No, he did not.
How much did he pay you for the study?
I don't know if I need to divulge that.
Well, I think you do.
Okay, I charged, huh?
Did he pay you?
Yes, he did.
How much did he pay you?
$1,900.
When did he pay you? Before or after you got the results?
As with all my clients, I get paid upon handing in the report.
Did you do any amendments or changes or revisions to the study?
No.
Nothing further.
Mr. Moore?
Just a quick follow-up. Again, with respect to the city's conditional use permit, the requirement is 65 decibels, correct?
Yes.
No further clarification, explanation, or anything with respect to how one is to determine whether or not you are at or above or below 65 decibels.
That's correct.
Okay. No further questions.
So that this board understands precisely what we're talking about. I didn't see anything in your report that said you couldn't measure the sound at the property line. You could do that, can't you?
Based on where I was told to do the measurements, I gather that was the property line.
Okay, I'm gonna agree with that. So it's possible for you to go out and measure the sound at the property line, correct?
Yes,
The challenge that you presented is, once you measure the sound at the property line, which is what's required under the conditional use permit, which requires, and I quote from section 400.240A1Y, 1C, sound amplification system or any other noise caused by the operation shall not exceed 65 decibels as measured at the property line, period, correct?
I have not, if that, could I read it? I mean,
I'm certain that Mr. Shroud or his lawyer would have given you the code which established the parameters so that you would know what you were doing, wouldn't it?
the code did not, in here, it does not tell you, 65, as I said up there in that very first thing, 65 does not clearly state what is meant by 65. If it's an instant or an average for a period. If it's instant, it's broken all the time for everybody.
Well, we're talking about a business operated by Mr. Shroud with the condition.
It broke on the days,
I didn't
okay,
ever interrupt you.
I apologize.
We're talking about one business under a conditional use permit that says 65 decibels, that's been in effect since 2003.
Okay.
Did Mr. Shroud ever tell you, hey, you know, I've been bothered by this measurement standard, and I don't think you can measure the way the ordinance says. 65 just doesn't sound right. Did he ever tell you that?
No.
I didn't think so. Thank you.
Another question, please. You've heard a lot of talk now about when's the appropriate time to measure, right?
Yes.
And we've heard some discussion that it should only be during the time of the racing event. I think we've already established that the conditional use permit specifies that the sound is to be determined based upon the time of operation of the racetrack. Operation could be opening, could be trucks arriving, delivery trucks arriving, could be fans coming in and out of the stadium. Is that correct?
Yes.
Okay. Board have any questions? I have a couple. You said you've done this for 42 years, am I correct?
I'm in my 42nd year of doing my line of work, yes.
Okay. And I'm sure you have some certifications and stuff involved in sound engineering and stuff, correct?
Yes.
Can you list those for us, or?
My certifications?
Yeah.
I have a degree in industrial hygiene, which that there is, I've also have attended, I don't know, hundreds of hours of training over the periods of years. Have been for the last 22 years, I've been out of the Navy, a lead instructor at the OSHA Training Center here in town, or in Kansas City area, I should say. And I do a lot with their environmental regulations.
You said you've done probably thousands of sound studies for different places, over 1,000?
Over 1,000 between the Navy, my 21 years that I did it in the Navy, and the 22 years since I've been out.
Okay. Have you ever done one on a racetrack before this one?
On an actual racetrack, I done a couple where racetracks were proposed at. So I never was called back to do the study once the racetrack opened up.
Okay. Have you ever done any before regarding like a city and the possible revocation of a permit where there's been sound issues?
Yes. In the state of Missouri, done one, which is now Interstate 49, down by Butler, Missouri, when there was the installation of a, talk about putting in, which they have put in these Walmart Center, they wanted to know what the impact study on that would be. I also was asked to do the study when they expanded out the Highway 7 from Blue Springs down to Coburn Road.
Okay.
And those were both 24-hour studies.
Okay. Just one more question. Do you have any idea how long, all the state and federal government, 'cause it sounds like EPA and all of them are kind of together, how long the standard you use has been, what's been used by the federal government? Any idea how long that's been the standard?
The ones that the EPA initially published something in the early 70s. If you give me a moment, I can actually give you the date.
Yeah.
The EPA promulgated the one that most everything's based on in 1972.
Okay.
Since then, they've pretty much left it up to municipalities and states to add or subtract. The state of Missouri they do have a couple of ordinances, but they do not state, at least from the state viewpoint, they talk about nuisance noise, but they do not give a sound level with that to go by. And the EPA study gave a 24-hour exposure, 70 decibels.
You said the state doesn't give like a decibel. Does the state have a way that is this how the state figures do they use the same standard when they're figuring their?
The state, when the state does studies, they typically, what I've known that the state has done is primarily been on highways, and they do refer to the federal highway standards because they're doing highway or road work. And that one there is actually a little bit louder than 65 for the area that you're talking about.
Okay. Okay. I don't have anything further. Thank you. At this point, do you have any more witnesses?
Yeah. At this point, no, we have no further evidence to present.
Okay. At this point, we're going on to closing statements, or do we do public first?
I'd like to make a few, I think what we intended to do was close the hearing. Close the hearing, and then you want to take public comment after that?
Okay, yeah, we'll do the closing remarks, and we'll take a short recess to set up for public comment, and then we'll do that. So, yeah, if you want to start with whoever starts with closing.
Well, I'm not gonna be very long, just turn that off now. Keep walking in front.
Yeah, I don't know how.
That's all right.
Sorry about that.
You know, you've been very patient. You're obviously all aware of the history. You've all been on board. You know what the problem is. I'm not going to repeat all the evidence tonight. I think it's clear, probably clearer to me, physically, I'm accused of sometimes not seeing the forest for the trees. But it's clear to me that we have a situation where Mr. Stroud doesn't want to take the responsibility that he should take. Folks, it's no different than any other regulation and ordinance in the city. This is a rule. If you violate it, you suffer the consequences. You have a right to drive a car. If you violate the speed limit, you prosecute. You have a right to operate a business. If you don't get a business license, you can be charged with operating without a business license. If you operate a restaurant or a bar, you have rules to follow. Mr. Stroud had 4 or 5 very simple rules to follow, and he's had a long time to follow. You've all been part of the process. You've been part of all of these hundreds or thousands of pages of minutes. You've been part of the collective decision that was made to give Mr. Stroud time to comply, time after time. You've been the ones who have been lenient and said, don't Board of Aldermen, May 13th, 2013. Directed staff to suspend citations, collect more data, find out what we can do to cooperate. That was more than a year ago. You're not asking for much. You really aren't. You're asking the person who operates the business to do it reasonably, sensibly, within the parameters established at the time of the issues. Period. End of story. If you believe these weighted average figures, so be it. I don't. I think it's manufactured testimony to arrive at a result. But even if you believe that, which I don't think, you have to look at all the other things Mr. Trout was required to do and didn't do. How many times did you give him the opportunity to correct his misdeeds? How many times did you say, all right, we'll continue to talk. We'll continue to say what we can do. How many times did he come in here before you? You saw the minutes. I didn't make them up.
No, I didn't make them up.
He came in there and said, I'll get you a sound study. I'll do a sound study. Oh, I can't find the sound study. I know I had a sound study. Well, never mind, my sound study mirrored your sound study. Then he comes in here tonight and he wants to blame the chief for not getting the fire plan. I thought the prior owner was supposed to do that. Well, come on, folks. When I asked the witness there, there's been common sense. That's common sense. You don't come in here to you as the board, the one who gave him the opportunity to operate the business, and say, oh, some other dude did it. Not my fault. You don't do that. You have to look at the permit as any other rule in this city. And what are we telling the citizens? What are we telling Mr. Trout? It's okay for you to come in here, thumb your nose at us, and blame you. It's your fault, you know. You didn't ask him. You didn't give him written notice. There's no requirement to give written notice. The only one who has to give written notice is Dennis Trout, Valley Speedway. And if you believe, like he believes, that he didn't know he was in violation, and that he didn't know he had time after time after time to correct, then I guess I missed the train. You have the obligation, and you remember what his lawyer said, by the way, when he started about preponderance of the evidence. He said that it was preponderance of the evidence. It's not preponderance. It's not clear and convincing. It's preponderance of the evidence. You got two stacks of evidence here. Preponderance of the evidence is which is the greater. It's not clear and convincing. That's a higher standard. It's not beyond a reasonable doubt. That's way up. Mr. Moore came up to you in opening and he said, well, you know, what you're doing is discretionary. You don't have to do that. There's no mandate on you to revoke this permit. Well, of course there isn't a mandate to revoke. But there is a mandate to you as board members and you as the mayor to enforce the ordinances of this city. And a conditional use permit is a privilege. It's not something you just take for granted. It's a privilege. And you have to respect it. And you have to respect you for what you've done for 8 years. And probably the last 4, when there's been an obvious, open problem with compliance. The mayor, with your concurrence, a year ago, May of 13, said, all right, we're going to suspend any enforcement. We're going to give him another bite of the apple. He's going to bring in another sound study. Have you ever seen a sound study? Until this one, whatever this was? I'm not sure this is a sound study, but whatever it was, it's the first time you've seen one. It just kind of defies logic to me. Because it is. When I told you this evening that it was simple, I think it's very simple. He didn't do what you told him to do. It isn't your fault. You're not a babysitter. He's a big boy. He can operate his business, but if he's gonna do it the way you told him to do and the way he agreed to do. Because if you don't, how are we going, how are you, how am I, city prosecutor, how's anybody gonna enforce anything in this city if Dennis Stroud can come in here and say, well, I didn't do it because I thought the prior owner did. I didn't do this, I say, well, I couldn't find it. Come on, that's not the way we run a city. That's not the way you run a city. So I'm suggesting to you that it is mandatory that you give this very serious consideration. I'm recommending to you that you revoke. I'm recommending to you, you go back and deliberate and talk about the procedures with your fine counsel. And come back, and when you come back out here, I urge someone on this board to make a motion to revoke the conditional use permit, because he has not complied with what he's supposed to do.
Mr. Mayor, members of the board, it's been a long evening, and thank you for your enduring all of this testimony. Have to admit, I'm not sure I was at the same hearing that my esteemed counsel was at, because I'm not sure I have the same conclusion that he's arrived at. I think, in fact, we haven't seen evidence this evening of my client blaming the city that it's the city's fault. What we've been saying repeatedly throughout this, that there is a proper procedure that should be followed. I mean, let's talk about common sense. There's a proper procedure and common sense that ought to be followed when you are taking away somebody's livelihood. And that common sense ought to be provide them with written notice that they're in violation. I mean, there's been a lot of talk, there's been a lot of discussion, but let's provide a written notice and let's say, Mr. Shrout, you were in violation of blah, 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 blah. You have 30 days to come into compliance. That's how most municipalities operate. And I would submit to you that that would be the appropriate way and procedure that you should follow. Now, with that said, I think we've provided evidence tonight through our testimony, through Mr. Shrout and Mr. Leichtai, that Mr. Shrout is in compliance. I have not heard any evidence necessarily that he's not in compliance. At some point, there could have been something that has been filed. There's been no testimony at all whether or not there's ever been anything on file. Our client has indicated that he thought the prior owner filed a plan. Well, you know, if in fact the prior owner had filed a plan, that would have complied with the conditional use permit. So I think what we're really talking about here is again, we're talking about common sense. We're talking about, hey, when we're enforcing a revocation in this manner, which is a draconian movement, we ought to go out of our way to make sure that we are following proper procedure, to make sure that the property owner has full opportunity in which to cure any defects if in fact there is one. And I would submit to you that under Missouri law, and we have cases that we can provide to Mr. Kapke, it's Gray versus White, it's a Missouri App case, it's 26 Southwest 3rd, 806, that would suggest to you that a municipality seeking to revoke a conditional use permit has the burden of proving basis for the revocation of the permit. Furthermore, as a matter of public policy, the law favors the free and unrestricted use of property. Zoning ordinances, being in derogation of the common law of property rights, should, whenever ambiguous, i.e., whenever you plug a number in without providing detail on how that number is to be determined, should be construed strictly in favor of the property owner. Owners who have been issued conditional use permits have vested rights to continue business as long as they conform to the conditional use permit and cannot be subjected to new conditions due to changing conditions on nearby property. Furthermore, in the case of McDonald versus City of Brentwood, which is 66 Southwest 3rd 46, the Moab case of 2001, a revocation of a conditional permit is a discretionary act. The zoning code does not require revocation. What we are asking for tonight is that we would respectfully request that you not revoke the permit. That instead, what you do is you go back, you deliberate, you come back out, and you direct the staff to negotiate with our client if you've got issues with respect to how these conditions are to be determined, and we try to resolve those issues. We've always been willing to try to resolve those issues. We don't feel like we've had a fair forum to go through that resolution process. One matter I do need to point out before I close, and that's we would respectfully request, since this is a quasi-judicial proceeding, that findings of fact and conclusions of law be prepared and concurrent with the action that the board has taken. Finally, I think, just to reiterate, we don't believe there's been a violation. We don't believe there's been a showing of a violation. We believe, in fact, that our client has attempted to cooperate with the city and to do things to improve the conditions and reduce the sound and the adverse effects, if there are any, to his neighbors. They have enacted the goal to end this racing by 11 p.m. They conduct mandatory functional muffler checks. They've enacted a policy to run the last race of the night using the quietest vehicles. They've enacted a rule that would mandate the maximum RPM be at a chip of 8,000 RPM on a per vehicle basis. Pursuant to the Cook-Flatt-Strobel study that was done in 2010, they did install sound barriers, installed and require additional mufflers. And we would submit to you that because those efforts were undertaken and those actions were done, that the 2010 sound study is of very little value at this point. And I would submit to you that if, in fact, the city felt, pursuant to that 2010 sound study, that my client was in violation, a notice to a violation should have been issued and proceedings should have been undertaken at that time. To now rely on a study that is now 4 years old, I believe it's out of date, and I think it's unreasonable to rely on that study. I'll point out one other thing. We're talking about the time-weighted average. When you look at, and you have it in your as an exhibit in your materials, when you look at the Cook-Flatt-Strobel study, it is using a time-weighted average. It's just using a shorter time. Again, your special or your conditional use permit does not specify the time. It's for the operation of the facility. The study that was performed in 2014 was for the duration of the operation of the facility. For these reasons, we would respectfully request that you not revoke the permit. Thank you.
Done. You done? Done? Okay. Okay, at this time then, we will take a short 5-minute recess to set up for public comments. And when we start those, I will repeat the rules we're going to follow for public comments tonight. So we'll take a 5-minute recess.